second incident, I'm told that shows very little of the altercation, but would y'all like to see it? And then abundance of caution. Same thing if you play it up there, please. This will be court's exhibit number 2, Angela.
Attorneys?
Is it going?
Yes.
anyone want to be heard with anything additional relating to the issue of competency?
Judge, just additionally, and again, based on how everything developed this morning, we attempted to get Dr. Krasanik all the records on the short notice. We found one additional that he did not review that I would like to introduce as an exhibit, and that is just a grace point intake note. Mr. Whitehead was not admitted. However, the note speaks to him reporting himself to Grace Point in December of 2017, which would have been after the prison record of Dr. Krasanik. He was not admitted. He was not even referred for inpatient services, but as part of the record, so Your Honor has the benefit of that, because I know records and all that came up. I'm having Ms. Freestone, if possible, print that exhibit, and we'd like to introduce that at Exhibit 3.
All right. You received.
Mr. King has an additional, I think, takes place on record before we
Sure.
Although that we can all look at these circumstances and have our suspicions about what's taking place, defense suspicions that there are serious concerns that raise the prospect that Mr. Whitehead is incompetent. And I believe the court has to find that there is no sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding. And I agree that the first determination here is going to be whether or not Mr. Whitehead suffers from a mental illness. And I don't know whether or not we can fully determine that based on what we've observed, either on video or based on the facts of the case or Mr. Whitehead's behavior, except to say that he is engaging in very irrational behavior in court, out of court, in his communications with his attorneys. We do know that he spent 10 years of abuse.
That's your word, irrational.
Right.
All right.
And that's all we can really go on in terms of whether or not we believe that he has an ability to communicate rationally and intelligently with counsel. So far, he has not, for whatever reason, as we rapidly approached the trial date, he became less and less able or willing to do that. And I don't know if it's ability or willingness. We don't know whether or not it's volitional. There are indications, at least one indication of paranoia in the DOC records. We take into consideration the nature.
Again, that's your word, and there's no evidence of that.
Correct. The nature of the present charges and the stress that may weigh on Mr. Whitehead psychologically, and the pattern of conduct leading up to including jury selection, are sufficient indicia for this court to have a question about whether or not he is able to proceed. Dr. Xavier could not determine the presence of mental illness. He has no idea whether or not...
Nor the presence of stress, either. Again, that's your word.
Right, correct. This is our... So we all know Dr. Farzani could not determine the presence of mental illness. Could not determine whether or not, could not say one way or the other whether or not Mr. Whitehead is suffering from mental illness. So there's not one professional so far who can comment on the origin of Mr. Whitehead's behavior. We don't know where it's coming from. And so given the fact that none of this right now is a qualified mental health professional, the one mental health professional that we did call cannot conclude one way or the other whether or not there's the presence of mental illness. With limited observation and no conclusions being made, leaves us with the question of whether or not Mr. Whitehead suffers from mental illness, which may be leading to his lack of cooperation in his proceedings.
It leads you to that question. I don't have that same question. So again, I want to point out that you're making an argument that this is not evidence.
Correct.
There's no evidence of stress. No one testified about any stress. You're again assuming that the words that you're choosing are what he's experiencing, and that is total speculation.
Right, and often when dealing with competency questions, the court will ask the attorney whether or not the attorney has any concerns, whether or not anything is taking place which gives rise to that concern. And so what we are sharing is those common everyday observations that we make of our client. And Mr. Whitehead's behavior is not rational.
And you represented otherwise up till this morning.
That's correct.
All right.
So the fact that he's coming in and out of his levels of cooperation tells me that there's something wrong with him. If he were consistently not cooperating, then that might be an indication of malingering. But the fact that he chooses to cooperate one day after intense encouragement by Mr. McNamara to come into the courtroom, which would almost, which practically rises to the level of some kind of coercion, please come in, have him talk him into it, and then backing out of that. The fact that it's back and forth is unusual. I've not encountered that. I've been doing this long as many people, but in 16 years, I've never encountered that kind of behavior from a client as we approach the trial date. Normally, it's absolutely no cooperation or it's full cooperation. The fact that it comes on and off is of concern. So, up to this point, I think from the last time at pretrial conference, Mr. Whitehead had a consistent pattern of cooperating with me and interacting with me on his case. Then it started to shut off. And only yesterday, we had to encourage him twice to come into the courtroom. There hasn't been an opinion proffered to this court that Mr. Whitehead does not suffer from mental illness. We would ask the court to exclude that possibility in order to fully protect his due process rights. There is enough for this court to have concern at this point for that determination. Maybe we should have another expert come in and look at it. Maybe another expert in looking at this document. Defense Exhibit 3. This is dated December 7, 2017, not long after Mr. Whitehead's release from DOC. He goes to a triage assessment at Grace Point. The report reads, Xavier is a 27-year-old who arrives at AES via self, so he's self-admitted. Says in his report, he reported that he is tired. Patient reports that he has been in prison for the last 10 years for armed robbery. Patient reported that he was 17 years old when he was sentenced to prison and was just released in May. Patient appeared frustrated and stated, I have tried to work and make a life for myself, but it has not been what I thought it would be. Patient reported that he is having HI. I do not know what that means. Stating that I don't want to be on the streets. I feel like I could just snap and go off instead. Patient reports that he is currently homeless. Patient stated that he feels like something tells me things in my head that has been bothering me more lately. It will tell me bad things and good things, and I try to push it away. Patient denied SI, I guess that's suicidal ideation. History of suicide attempts, so he's never tried to commit suicide according to himself, and he doesn't have suicidal ideations. Patient stated that he wants help with homeless services. CM provided patient with referrals to the Salvation Army so he can go from a transitional housing program. Patient appeared cooperative, anxious, frustrated, elevated, intact memory with a sad effect. Based on our observations of Mr. Whitehead leading up to this trial, it doesn't appear as much has changed in terms of his ability to control these thoughts. And I would just ask the court to at least invite another mental health professional into these proceedings to see what they can make of all the evidence and all the indications so we can have a more certain idea of whether or not there's the presence of mental illness leading to competency concerns. We would once again offer to the court our position that he is incompetent to proceed at this point.
All right. Anything the state wants to add? It's not required, but I'd like to add something that I haven't considered before. You can.
No, I just want to note for the record the state is in opposition because obviously Mr. King has made a series of representations under which I can cross or contradict or rebut. I'm certainly not going to suggest that he's being dishonest or deceitful with the court. That being said, Your Honor has witnessed the behavior, the escalated behavior of Mr. Whitehead. And the state's position is that he is feigning any sort of illness at this point to delay the trial. That's all I have.
Also, Mr. McNamara and I spoke with Mr. Whitehead and discussed with him there's a state possibility that if this court does not find that sufficient indications to have him committed for competency restoration, there is a strong likelihood that the case will go forward without his presence if he chooses to absent himself from the trial. And we did not get any response. I also advised him of the potential impact on any sort of appeal. And I don't know what that impact would be, but I couldn't comment on whether or not there would be one. And if this court was going to make a ruling, and I encouraged him once again to participate and get dressed and come on out. And we did not receive any response.
Right. And as Deputy Edwards testified to earlier, he has been offered again a chance to join the proceedings and has not availed himself of that opportunity. I'd cite Mohammed versus State, 4947 2nd 969, Supreme Court, July 1986. Sampson versus State, 3rd DCA, October 2011, 88 7 3rd 209. And the plethora of cases that follow after that, dealing with instances in which the defendant does not cooperate or subject himself to the evaluations being ordered by the court, and that thus requiring, not that the court find him incompetent based on that, but requiring that the court make its own independent observations and conclusions about competency. Recognizing that the court is not a mental health expert either, but certainly can comment on the daily interactions exhibited by Mr. Whitehead. I've seen him on Thursday, December 12th, I'm sorry. When we back up and we start from the beginning, on Tuesday, November 19th of this year, where we had a motion with several motions in limine as it relates to evidentiary issues in the state, in which Mr. Whitehead was present at that time and cooperated with counsel and interacted with counsel and seemed at least overtly to the court to understand the court's ruling, and we were in court for quite a period of time on that day. I again saw him on Monday, December 9th, where we left the date set for trial. I inquired at that time if he had counteroffers to relay to the state. He did not answer my questions at this time, exhibiting a tendency not to participate in the proceedings, at which time defense counsel indicated, despite that failure to participate in the seizing, they had no reason to doubt competency at that time. I will supplement the record, or at least comment on the defense position as it relates to jury selection yesterday. He did refuse to participate in the proceedings after that, regardless of how much it took to talk him into it. He did participate in the proceedings. I observed him interacting and speaking with both defense counsel, the jury consultant, Ms. McNamara, that was on the case, Mr. McNamara, the investigator that was with you on the case, as well as both attorneys, Ms. Fulgera and Mr. Kidman, and find at the end of those proceedings, when I asked him if the jury was acceptable to him, I misunderstood him at first, and he corrected me to say that yes, he did understand the nature of the proceedings, well, not that particular question, but that he did accept the jury panel, as indicated before. As also has been indicated on the record, he was in the Department of Corrections custody for 10 years, of which no one can identify any reason to identify any mental health or substance abuse or mental health or competency issues that arose during that pendency of 10 years. I point out that both of those, that 10-year sentence were case number 08 CF 15794, 07 CF 18862, to which he entered a negotiated plea for 10 years in the Florida State Prison here in Hillsborough County back on 2/1/2010. 10. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 2010. 20 at which time the court found that his plea at that time was freely and knowingly, voluntarily entered, and he understood the ramifications and circumstances of the plea. Even the evidence that you just tested, or just presented to me, not testimony, but conclusory regarding his trip to Grace Point was mostly as it related to homelessness issues, not as to any allegations of mental health. It's mental health diagnosis, as we all understand, are quite otherwise, that he does have an ability to consult with his lawyer, and I'm not going to be put in the position of making a subjective judgment about whether or not I think he's scared or the reason for his non-cooperation. That's not of any consequence to this court. But the court, and the case law does provide that the court can make those findings in light of anticipated circumstances that occasionally instances arise where defendants are not cooperative in order to proceed with their proceedings. And I make those findings based on my visual and auditory observations, as well as everything that's been put on the record thus far. I find it competent to proceed.
Thank you, Your Honor. Is there a way we need to fashion an instruction? Obviously, the jury is going to notice that Mr. Whitehead is not present.
Yes, I'm going to tell them that to disregard it, just as we instructed them on his right to remain silent, that the question of whether or not he's present in the courtroom during any portion or all of these proceedings is of no relevance to the question of whether the state proves guilt beyond a reasonable doubt.
Thank you, Your Honor. And obviously, Mr. Whitehead can hear us as we're speaking now.
Yes?
And can we just one more time encourage him to not go on the floor and let the deputy know if he wishes to join us?
Yes. Can you make sure that Deputy Balista just heard that request and asked him right now, and then he can respond with his response?
Just one final invitation before we bring the jury back.
Sure.
Thank you.
Your Honor, just for my planning purposes, assuming the defendant is going to continue to absent himself throughout the trial, I'm not sure what Your Honor's inclination is.
Yes, sir.
I wanted to ask that he be brought in for purposes of being reviewed by one witness in the flesh, or if I should plan that he will not compel him to come into the courtroom, and I think there's some other way to link up identification since he won't physically be in the court.
Okay, are you ready? Sir. No, he does not want to come. He says his head hurts and he wants to lay down.
Right. Thank you. That was in response to the question.
Yes, ma'am.
Thank you. I don't know. Do we have to answer that question today?
No, it's just the further along we proceed, the less and less time I have to fashion. I will tell you that if the court was to entertain my request to bring him in the flesh, either my second to last or last witness, Corey Jackson, is the witness that I would ask you to have him brought in to get identified in person. But if we wait until that time, we're basically running out of witnesses to fashion some other sort of solution. So I will just begin preparing for the possibility that you may not let him come in the flesh.
All right. And you can certainly discuss with the defense any alternatives that they would like to stipulate or agree to with you, so as to minimize any of their perceived harm in him not being here in person. So anything we want to do to accommodate that and make it more palpable to the defense, I would certainly allow that to happen. So,
Yes, sir. Thank you.
all right, I suggest you attempt to resolve it between each other before you ask the court for help, in other words.
Yes, sir.
All right.
Judge, can you also inquire of the jury, because of the unique circumstances of the live streaming and what's occurred today, they've been
Yes.
exposed to any